One, that the defense had brought up the matter of lack of jurisdiction, yet at the same time raised issues that it required the court to address in form of objections. Two, issues were raised without specifying under which law until the tail end when it was stated that it was under Articles 50, 29, and 19 of the Constitution. Three, no submissions were made on powers of the DPP to institute criminal charges. Number four, no objection was made as to the form and quality of the charge as required under Section 89 of the CPC. To the direction sought by the DPP on whether she should respond to the application in view of the issues raised, it is my considered view that whenever an accused or indeed any person appears before the court, the primary responsibility of any court should first and foremost to accord that person the opportunity to speak out and even pour out their hearts or spirits on anything that worries them in respect to the accusations or the cases leveled against them. As a court that is keen to do justice in the case, formalities such as issues were raised without specifying under which law they were raised or premised upon should not be an obstacle to hearing a concern that a party is expressing. Indeed, under Article 159(1)(d) of the Constitution, the court is obligated to administer justice without undue regard to procedural technicalities. Hence, the mere fact that the application was made without specifying which sections of law it was brought until the tail end is not, in my view, a ground for saying that the issues raised are unworthy of reply. In my view, the state should have picked out any issues it believes it's worthy of its reply and leave those that it's of the opinion do not prejudice exposition. And in fact, the issues raised by Mrs. Dorcas Orwell, though couched as matters which she seeks this court's direction on, are in a way a direct and unambiguous counterattack that could probably form part of her submissions, so that the court has an opportunity of considering if the said contradictions as to where she says the defense has argued about lack of jurisdiction and at the same time raised issues for consideration by the court, if any material consequence would arise out of that. In my view, I cannot, on the basis of issues raised by the state, dismissively hold the arguments or concerns raised through the application as unworthy of any response or consideration by the courts. It is the best way the accused or defense could present the matter to the court, and the court has an obligation to consider and tell them whether it has merit or not. For that reason, the decision, if this court the decision should be left to the state choice. It may choose whether to respond or not, but ultimately the court cannot and will never turn away its ears to a party's concern. Hence, even if the state chooses to exercise its right not to respond, the court must make a decision on issues raised before moving to the next stage. Orders accordingly.
Your Honor, we have since extracted the order in petition number 259 of 2018, 295 of 2018. We have served the DPP with the order, and my learned friends for the second accused also have seen the order and interrogated. I will now deliver a copy to the court. No, take this one, the seal. The one I'm giving the court is going to seal and stamp on the court. It's not a copy, it is sealed, a proper copy. And invite the court to look at more particularly the order number 5. which stays these proceedings and also set out other orders for purposes of preparing for the hearing of the petition. And there's a mention on the 9th of this month, of October, on which day the court will give.
There's a mention on 9th, eh?
On 9th of October. And further directions will be given on that date. So not only have we, there's a stay, and on top of it, evidence to show that the matter is now actively before the High Court. So, Your Honor, I'll sit and let my colleagues respond to it. My view in respect of whether there are any directions now to be made on the basis of the application that we made orally, on the basis of this order, which stays proceedings in this matter. Again, as I said in the morning, if there was any reason to down our tools, now we have no alternative but to down our tools, including the tools of the Director of Public Prosecutions. In this instance, you can do the others. But this one, down the tools.
I have been served with a stay order, but a casual perusal of the order number 5, which reads as follows: that an interim conservatory order be and is hereby granted staying criminal proceedings against the petitioner in criminal case number 292 of 2018 pending before the Magistrates Court. That is not the case you're dealing with today. That's the wrong number. So these proceedings have no been stayed. These proceedings are number 38 of 2018.